For our last panel of the day, it's titled "The Contraceptive Mandate, a Case Study." It will be, need my sheet. It'll be moderated by Joanne Koob, and of course she's an assistant professor here at the law school and director of the law school's Liberty and Law Center. I just want to add, if you don't already know about the Liberty and Law Center, please do also check it out. Its website, libertycenter.gmu.edu. The Liberty and Law Center was founded 2 years ago to advance discussion of the law's role in protecting and promoting liberty. If you're not already familiar with it, then please do check it out online. And since we are the Center for the Study of the Administrative State, I do want to point out that one of our panelists on today's closing panel is Renee Landers, the recent chairwoman of the American Bar Association's section on administrative law. If you're a member of the ABA but not a member of that section, then please do also sign up for that.
You can't
So
leave here without
that ends the infomercial portion of today's event. I'll turn it over to Joanne. Thank you, Joanne.
Yeah, thanks, Adam, for the shout out to the Liberty and Law Center. So we've heard a lot today about the contraceptive mandate, and so it's kind of fitting that our final panel will do a deeper dive into it. Our first panelist is Helen Alvarez. Those of you who are here this morning probably remember her introduction. Those of you who are not, I'm going to give a brief version of just a few of the highlights. Also, it's a refresher for those who are under-caffeinated this morning. Helen Alvarez is a professor of law at the Antonin Scalia Law School here at George Mason. She teaches family law, law and religion, and property law. She's also an advisor to the U.S. Conference of Catholic Bishops and consults with the Pontifical Council of the Laity and the Permanent Observer Mission of the Holy See to the United Nations. She publishes on matters concerning marriage, parenting, non-marital households, and the First Amendment religion clauses. She recently published a book, Putting Children's Interests First in American Family Law. With power comes responsibility. She wrote a paper in connection with a panel today, which she will be discussing. It has a rather provocative title, A Perfect Storm, Religion, Sex, and Administrative Law. So Professor Alvarez, we'd love to hear more about your work.
Thank you so much, Joanne. And again, thanks to this center for having us. Every time the contraceptive mandate was mentioned today, I was looking forward to having sort of the last word, at least the last panel. So I want to thank Renee in particular because we were together at the colloquy on this earlier, and because of remarks and comments that she made there, I was able to substantially, I believe, improve the paper. So I want to thank her in advance. I want to talk about two characteristics of agencies in connection with sexual expression matters in particular that can lead to poor science, which means poor medical health science here, and religious conflict. These are partisanship at agencies dealing with sexual health, in particular HHS, mixed with claims of scientific expertise on the subject. At a time, remember, when you may have seen recent studies, how difficult it is for most scientific studies to be replicated successfully, okay? This creates a storm in which the regulations can readily fail to demonstrate convincing medical excellence. At the same time, they're provoking either non-establishment or free exercise challenges. I'm going to talk about this in the following order. First, by talking about sexual and reproductive health in the U.S., just some of the data so you know that there's a real public health necessity to address it. Second, I'm going to look at what's called sexual risk avoidance under the Trump administration and the contraceptive mandate under the Obama administration for sort of examples that illustrate my central points, their content, their partisan qualities, each administration's claim to have science on its side, and how they provoke religion clauses claims, and then suggest some ways in which both HHS and religious actors could speak in order to ameliorate the science problem and the religion clauses problem. So, I mean, you read about this every day. Regarding reproductive and sexual health in the U.S., we have the highest teen pregnancy rates among countries with complete data. We don't have the highest non-marital birth rates, but they're way up there in 40%. We have more than double the teen pregnancy rates of countries like France, Israel, Norway, and all of it is disproportionately among the poor. Also, huge rise in sexually transmitted infections in the U.S., including not only the most common kinds, but even, interestingly, recently a spike in syphilis. We have 19 million new sexually transmitted infections annually, and the CDC estimates that 1 out of every 4 teenagers has one. We've got, and again, disproportionate among the poor. 40% of all births are out of wedlock, disproportionately among the poor, with intergenerational effects. People on, from the right to the left of the political spectrum on family structure really tend to agree about this. Agency policies, of course, are not all there is on this, but the money at their disposal, the messages that they send are large players in the field, reaching all 50 states, involving a tremendous amount of money annually, regularly in the press, influencing public discourse. We've had really activist HHS voices in at least the last 5 presidencies. It would really be a shame if these voices were more political than scientific, and also a shame if a lot of money is getting wasted on religion clauses challenges that could be avoided. So let me talk about 2 agency actions affecting sex and reproductive health that I want to focus in on. The first is what I call the sex ed wars. The Obama administration went all out with what's called comprehensive sexual education, including teaching about the use of contraception, and very much promoting it as if it could be a big solution to the problem. The current administration is putting out sexual risk avoidance, which is, each of these could be described at further length and may have more elements, but talks about the maximum standard of health to be avoiding sexual intercourse before marriage as healthy for you, healthy for the kids. Either of these programs, comprehensive sexual education or sexual risk avoidance, CSE or SRA, might have other elements, right? They could be talking about relationships, life, additional things, but each of them also has a primary focus. The Obama administration, cut short the SRA type programs. The Trump administration has cut short the CSE programs and given more money to sexual risk avoidance programs. There are claims, scientific claims made on both sides, depending on who you go for evaluation, but because of the short time I have, I can refer you to the paper for more medical citation footnotes than you really want to look at to show that both programs have a few programs that show some very partial benefits depending on how you measure them over limited periods of time, and depending on the audience, male or female, could differ according to race or ethnic origins. Neither of them is any silver bullet. Neither of them reaches gigantic percentages of the population. And both of them are usually accompanied by intense claims about their absolute necessity for addressing the crisis of especially teen pregnancy in the United States. Problems with these sort of somewhat overblown claims. Frankly, the decline in teen pregnancy is not like, it was the teen pregnancy prevention CSE programs. That decline began 2 decades before the Obama administration started deploying these programs. Teens' decisions about abstinence, a big thing in the news. Teens are more abstinent than they were before, a fair amount more. Played a fairly big role in that. And the other thing to say about teen pregnancy is, sure, we may have less of it, but that's because teens aren't getting married anymore. We actually have far more non-marital teen pregnancy than we used to have. So we have more non-marital teen pregnancy than we had years ago when we first started measuring this, even as we have less teen pregnancy. Before, something like 89% of teen pregnancy was in marriage. Now, like 89% of it is single folks. So the idea that we've made these great strides with teens, well, it's really more about teens deciding not to marry anymore. And as I mentioned, some of the major claims about what constitutes improvements in either of these programs are really in things that people would not regard as at the top of their list as what they wanted the government to fix. They want the government to fix teen and out-of-wedlock pregnancy. They'd like to lower the abortion rate. They'd like to lower sexually transmitted infections. What you're getting in a lot of these programs is short-term impacts on knowing more about contraception, or knowing more about sexual risk avoidance, or using a condom on first intercourse, or in some cases, short-term lower teen pregnancy rates. But neither of them is a silver bullet. Both programs claim science on their side, and to a certain extent, both of them are using, evaluators like Mathematica and other classic Beltway evaluators. Both of them are demanding scientific standards. What they're not getting is incredible results that really justify a very intense political fighting against each program as if neither of them has anything good to say for themselves, and both of them, in the eyes of the other, have something evil that they're doing. The SRA programs have provoked establishment claims. Of course, many religions teach that non-marital sex is immoral. Some also, like Roman Catholicism, oppose contraception. A lot of religions oppose abortion. So you can imagine that an SRA program is going to be accused of overlapping with religion just too much and of being an establishment of religion. And you get a lot of that, even though the Supreme Court in 1980 has said, listen, we have a lot of government programs that do a lot of things that are, claimed to be moral. And just because they overlap with a religious position does not make them religious. So when Nancy Pelosi says that St. Joseph wants her to pass the Affordable Care Act, we don't say that is an impermissible establishment of religion. Just as when you have an overlap between abstinence, sexual risk avoidance, and some religious positions, the Supreme Court has said, no, that doesn't make it an establishment of religion. The second sexual policy that I want to talk about is the Obama-era contraception mandate. It's come up so much today, and I have so much written on this. Let me try and summarize it. I don't have to tell you what it is, because you already know. I will talk about the partisanship involved. President Obama was absolutely the best presidential friend Planned Parenthood ever had, the only president who ever spoke at their fundraising dinner. Kathleen Sebelius was feted when she was in Kansas as the champion of the Planned Parenthood cause. Regarding the information on the last panel about wide consultation, the ACA said there had to be preventive health care for women. They handed it over to HHS, who handed it over to the Institute of Medicine, who then hired a panel of 16 people, 9 of whom were prior chair or board members at the Planned Parenthood Federation of America, and several others being people who had already written for Guttmacher or strenuously in favor of Planned Parenthood Guttmacher outcomes. In 1 year before they were appointed to the panel, members of the panel had given $116,000 to Planned Parenthood as donations. They did not have the largest provider of private health care from religious background in the United States to testify. They had Planned Parenthood, they had Guttmacher, they had other abortion and contraception advocate groups, whereas the Catholic group that provides 1 out of every 6 hospital beds in the United States was asked to stand in a line with everyone else at the microphone. So were all the other religious groups. And if you actually ask about wide consultation, the religious groups will tell you it never happened. When it finally came out, the Institute of Medicine report, word for word, mirrored a Guttmacher Planned Parenthood recommendation that had been made in the 1990s. It was word for word. As Professor Rienzi said, it was more of a political statement than it was a healthcare statement. Michael Weir, who worked in the Obama White House, in his book about his time there, speaks of it as an out-and-out attempt to pit Obama against Mitt Romney during the election. The science of this, and I know I'm going over a little, but let me just take another 2 minutes because I feel like I need to tell you about it. They said it could prevent unintended pregnancies, but unintended pregnancies were identical even after 50 years of spending $2 billion a year on contraception. They said it could prevent abortion. Abortion rates actually went up after contraception was issued, and both unintended and abortion rates went up most among the populations given free contraception by the feds. They said it could help women who shouldn't get pregnant with particular conditions to avoid getting pregnant. Turns out all of their medical associations say the last thing you should do with those precise conditions is swallow contraceptive synthetic hormones. It said women spent more on contraception. It turns out Dianne Feinstein kept saying it, then it kept appearing in the HHS cases. If you actually got to the root of the claim of the 58% additional cost, it actually was a Medicaid report that said women spend more on health care because they have babies, live longer, and go to the doctor more often. Contraception is completely unrelated to women's health care costs as compared to men. It talked about the health benefits of it, and again, you'd have to look at my longer paper on this, but there were equal numbers of papers saying it had health risks. The National Cancer Institute, the World Health Organization, and that it was unrelated as a causal factor. So the science was a big problem, and I did an article, it's like 70 pages, just undoing every scientific source cited by the IOM and later by HHS. My final remarks regarding sort of how do we come together to do better science and avoid religion clauses, clashes. With regard to, and you know, I don't even have to say, 300 plaintiffs or so, 100 cases against the mandate, constant lawsuits or in law review articles and turmoil about whether sexual risk avoidance is establishment. A couple of very incremental recommendations that I usually make. First of all, I would love to see more people talk about actually coming together to make real thorough consultations and fair recommendations regarding a true sexual health crisis, especially among the young and most especially among poor Americans. I would like the acknowledgement on the part of the agencies that there are often competing credible positions and that they are taking a bet or that they have adopted a value judgment. This is going to Professor Vermeule's, cost-benefit as a faith-based initiative. These decisions about who the human person is in connection with sex, marriage, and parenting are anthropological value judgments. And frankly, there's a lot more empirical evidence that they could look to say whether they're right or wrong about that bet. I think they need to have modesty about their programs, which only affect tiny subsets of Americans, and they need to have the same openness to correction as every other government program that doesn't deal with the neuralgic subject of sex. Head Start is acknowledging it has almost no good data. They're trying to revamp it constantly because it's a good idea, and they need to revamp it. But these programs always partake more of the language of partisan fervor. To avoid establishment and free exercise claims, again, I love Professor Vermeule's idea about doing sort of a look as to how these things affect religion in advance and to have an impact statement on that. I think we need to acknowledge that some positions do overlap with religious values, but they're not establishment, and that religious actors themselves have to be really transparent and even forthcoming in advance that they're not using the federal money, if they do these programs that they get with federal money, to advance religion. Finally, with regard to free exercise, I think the agency has to acknowledge that it is carried out in religious groups, and I could go on more about that in the comment period. The religious actors need to do two things. Number one, they need to articulate for the public how true it is that as Pope Francis says, their social services are as much a part of their religion as scripture and sacraments. Mother Teresa is not less religious because she takes care of anybody who happens to need a secular service, which is health care. I think finally they also need to explain that the burden is not you commandeered my health care plan solely. The burden is we are communities trying to put forth a particular image of sex, marriage, and parenting in an incredibly hostile environment to our teachings right now. We're considered to be mean, irrational, anti-gay, anti-women. We have to have a community that is fed by these practices that we have. And frankly, I think this belongs less under just free conscience or conscientious exemptions than it does under church autonomy as a community to live according to and manifest a way of being that says sex is also about tomorrow and children are our responsibility and we have to be responsible. So, sorry it was so much, but there you go. Thank you.
Thank you, and we are fine with you taking a few extra minutes. Our second panelist is going to be Renee Landers, who's at the end of the table. Professor Landers is a professor of law at Suffolk University Law School, and she's the faculty director of the school's Health and Biomedical Law concentration. She teaches administrative law, constitutional law, and health law. Last semester, she served as a distinguished visiting fellow at the National Academy of Social Insurance. She's worked in private practice, and she served as Deputy General Counsel for the U.S. Department of Health and Human Services and as Deputy Assistant Attorney General in the Office of Policy Development at the Department of Justice. Currently, Professor Landers serves as a member of the Committee on Judicial Ethics and on boards of the National Academy of Social Insurance, Massachusetts General Hospital, and New England Donor Services. She's a busy lady. In addition, Professor Landers has written about the Affordable Care Act, healthcare disparities, and affirmative action. She regularly provides comments for print, television, and radio on the Supreme Court, healthcare, and administrative law issues. Professor Landers, I'll turn it over to you.
Great. Thank you very much, Joanne, for that really kind introduction. And I want to also add my thanks to the expressions of appreciation that we've all given to Adam today for organizing this wonderful conference. And I especially appreciate his shout out about people registering for membership in the American Bar Association and section of Administrative Law and Regulatory Practice. I think you'll find it you'll find a very interesting group of people and very interesting programs. I think Professor Vermeulen has won the writing award from the section in the past. Yeah, so there are a lot of people who have section connections here. It's a pleasure to be here at this law school to try to talk about some of these issues. One of the other things, there are two other things in my background that perhaps you should be aware of that might inform how you think about what I say. One is that I have been educated almost entirely in Catholic organizations, except for my college. And obviously I don't work for one right now. But I've also been one of those people who's been on the board of Planned Parenthood of Massachusetts. And so I do actually, have a particular viewpoint about what some of the goals of some of these things might be and what the access issues might entail. But I also, share some of the concerns that Helen has expressed in her paper and in her presentation today. I want to thank Helen very much for her paper. As she said, when I had the opportunity to look at the first draft last year, it was a very different paper that was and the final product here, I think, is a very much more balanced and nuanced presentation of what some of the competing concerns might be with respect to how we view these programs on sexual education, and then what has happened with the sort of the fallout from the contraceptive mandate. And I do really want to compliment her on all the work that she has done in the paper, because I think it really does help elucidate these issues, and I learned a great deal from reading them. One of the things that I think that is the points that she makes in her paper is that about the partisanship that has influenced the positions of different administrations with respect to some of these issues, or the, sort of bringing, the preconceived notions about how the outcome of the issue should, what the outcome of the issue should be. And I think that, as Brian was saying on the panel that preceded this one of the frequent criticisms of the administrative state is that it is really impervious to influence from the electoral process to the political process. And I think that Helen's paper demonstrates that, at least with respect to the contraception policy and the approaches to sex education, that this critique does not appear to be true. And I don't think that that's necessarily such a bad thing. I mean, we might disagree with a particular administration's approach to the particular problem, but it is certainly true that new administrations can come into office with a particular point of view about policy directives and actually make those views felt in the bureaucracy. That the administrative agencies can be effective translators of the president's policies for better or worse with regard to the public. So then as the discussion has gone on today, we have to recognize that there are better ways to do that than others, and every administration learns, mostly the hard way, that how they have to take action in order to actually have it come into effect. So the criticism of the HHS decision-making process on both of these policies, the education on sexuality and contraception, the contraceptive mandate, doesn't really resolve the question of how to take into account the asserted interests of some organizations in pursuing faith-based goals when they're engaged in activities in which other non-faith-based organizations are also major players. So, Helen mentioned mentions the statistic in her paper, and she mentioned it today, that 1/6 of the patients, hospital patients in the United States, receive their care at Catholic hospitals, which is true, and it's an admirable social enterprise of Catholic organizations in this country. On the other hand, the question is, do the patients who receive their care at the facilities have to be limited by any particular conception of what healthcare, what kinds of healthcare services people should receive access to? I think that's a big question. I mean, the panel earlier on labor policies, I think, raised the same issue. Are the rights of workers in these workplaces somehow less worthy of protection than the workers in other secular workplaces? I'll just use that word in air quotes. And that I think that the notion that we can accommodate the religious interests of these organizations doesn't necessarily take into full account the impact on patient populations, perhaps, and also employers. I know that Professor Rienzi in the previous panel, talked about the dearth of employees challenging the unavailability of contraceptive coverage through employer-based health plans. If you're the employee of the Catholic hospital that's the largest employer in your area, hard to stick your neck up and say that I'm going to challenge this policy of my employer. Also, and I think that that's a very hard thing to expect rank and file employees to do. It's the reason why on many of the cases, which I will call the reproductive rights cases, like Griswold, Planned Parenthood v. Casey, the plaintiffs are institutional litigants who provide care to patient populations and not necessarily the individuals themselves because of that problem of exposing the individual in that kind of litigation environment. So I guess the final comment I would make on that point is that it's not the same thing to say that having some sort of dividing line between the impact of religion on public policy or using public policy to give effect to religious principles. It's not the same thing to say that as it is to say that you're wanting to eliminate religion from the public sphere, because I think the two can be held in our minds that at the same time, that people who are interested in this separation are not necessarily interested in eliminating religion from the public discourse. So then, on the question of the education, of the sex education programs, I agree that one of the reasons that this is so fraught is because no one likes to talk about sex. And I guess that's sort of what's part of the problem with the contraceptive mandate as well, that everybody gets very uncomfortable. But we would also agree that people need to know about it and that young people need to know about it. And I agree with her that, that there is a tragedy of a public health problem among young people with sexually transmitted diseases, unintended teen pregnancy, and all of the health consequences and life consequences that flow from those situations. But I don't think that it's true to say, and I know she was painting a broad brush today, so I know that the paper is much more nuanced than this, that, the abstinence policies are only about abstinence, the so-called abstinence policies, and then the comprehensive sex education policies are only about teaching people about contraception. And I think that in defense of some of the contraceptive sex education policies, they really are contraceptive, starting from the premise of teaching people about how to engage in healthy relationships, what it means to think about your future and build a future life. And oh, by the way, that these sexually transmitted diseases and unintended pregnancy can really alter that life trajectory. So, trying to avoid early sexual activity and other kinds of activities that could lead to these consequences would be a good thing. And then, in addition to that, this is information about contraception. So I think that the idea that the comprehensive sex education policies are not actually educating people about the value of abstinence is really not necessarily accurate. And I certainly agree that a model that discusses, abstinence, parental involvement, science education about biology, including contraception, is the approach that we ought to achieve. And I totally agree with her about the statistics on the efficacy of some of these programs. So where does that leave me? I guess so I've said where I end up with respect to the sex education policies, but with respect to the contraceptive mandate, there are other bad health statistics that the United States has there. And one of them is that we have the highest maternal mortality rate in the developed world, 26 per 100,000 live births, again, heavily concentrated among low-income populations and certain racial and ethnic groups. So it's the notion that contraception is not at least a piece of the picture about promoting better maternal health and better health outcomes for the children born of women seems to me not to be an accurate view of the world. I think that with respect to all of these preventive services that ended up on the list that have to be provided at no cost under the Affordable Care Act, the contraceptive mandate is like all the others. Not every person will find a need for every item on the list. Not every person covered by a health plan will have a conversation with their physician recommends every single item. It's a nuanced discussion, but the point of the list of essential services is that they be available to all who might need them with the help and advice of their physician, so that it's not necessarily pushing and promoting that all these services must be taken up by every single person, but that they can be available for the people who want them and need them. So I'll stop there, and I look forward to responding to questions and engaging the conversation.
Thank you, Professor Landers. Our third panelist we'll hear from today is Diana Verm. She is senior counsel at Beckett, where she's been litigating since 2009, so she'll provide us with a perspective from having litigated some of the cases we've talked about today. Her work has run the geographical gamut, including defending the Pledge of Allegiance in public schools and supporting the right of New Zealand's Jewish population to have access to kosher meat. Diana has been featured on Christian Broadcasting Network Television, EWTN, and C-SPAN. She served as counsel in Zubik v. Burwell, where she represented the Little Sisters of the Poor, East Texas Baptist University and Houston Baptist University at the Supreme Court in the nonprofit challenge to the HHS mandate. And in the Hobby Lobby case, she challenged the HHS mandate on behalf of for-profit businesses. She also served as counsel in Singh v. Carter, challenging the Army's dress requirements that prevented observant Sikhs from serving in the military, and in Moses v. Ruskowski, in which she defended a New Mexico state program that lends textbooks to students from a challenge that would have forced it to exclude students at religious schools. Diana, we'd love to hear from you.
Thanks so much, Joanne, and thank you, Helen, for this article. I do think it's really helpful. Since I am a litigator and since I have been litigating the HHS mandate case since the very first complaint was filed against the mandate in November 2011, I thought it'd be helpful to talk a little bit about the role of litigation in some of these intractable conflicts that do involve political views of the agencies. And I agree with Helen that in an ideal world, it's best if administrative agencies can use the science and the secular principles at their fingertips and take into account religious objections and religious interests. And as my colleague Mark said in the last panel, with the agency's powerful tools, they should be able to find a way to get contraceptives to women without using nuns. But since they didn't, we have this almost decade-long conflict, excuse me, involving dozens of lawsuits, hundreds of religious plaintiffs, multiple Supreme Court decisions, including very unusual emergency injunctions. And one way to look at this is the way that the HHS mandate was rolled out, and Helen mentioned this a few minutes ago. People were not sure what to expect once there was a huge public outcry in response to the mandate. They posted the mandate on their website, and it took effect almost immediately. So you have these religious objectors, and you have these lawsuits being filed, and the administration decided not to back up. They took the path of most resistance, as Helen says in her article. They delayed implementation of the mandate for the nonprofits for 1 year, and they worked on what they called an accommodation, which turned out not to be much of an accommodation, as we've heard. And they expanded the religious employer exemption, so it applied to churches and a few other organizations. And they went full steam ahead on the for-profits. So you have all this litigation, and the for-profit cases are going first, and that's why Hobby Lobby was 2 years before the Little Sisters of the Poor at the Supreme Court. And that gamble turned out to be a loser for the administration because Hobby Lobby won, and so you have this great religious liberty decision in Hobby Lobby, and then you have the administration trying to respond to the accommodation for the for-profits, and then you have the nonprofits coming up the pike with the Little Sisters. If you look at the situation we have today, you have a patchwork of injunctions against the HHS mandate across the country. You have a religious exemption from the new administration that finally solves the problems for religious objectors. And you have a nationwide injunction against that exemption and ongoing litigation in at least 2 parts of the country. So these cases are expensive for the government to litigate, and they're expensive for the religious objectors as well. And they fuel culture wars, which is not a good situation to have. That's a negative outcome of politics in the administrative process, and hopefully litigation in that case poses a cautionary role for regulators who want to go with a view to making political points. They'll be subject to litigation. But litigation can also be a positive tool, and I'll just mention 3 or 4 ways it can be. First, when agencies take political positions like this, courts can curb those positions in ways that you get clear court decision with future precedent. So we saw that in Hobby Lobby. And you also saw that in the Hosanna-Tabor decision where Judge Duncan mentioned earlier that the administration argued there almost shouldn't be a ministerial exception at all. And you got a 9-0 decision from the Supreme Court unanimously saying, no, there's a clear ministerial exception. And I do think that this administration has learned a little bit from that. It left the mandate in place for everyone. The mandate is still just on a website. The list of preventive services is still just on a website, so they could have taken that off. But they left it in place, and they offered a religious exemption and a moral exemption for those who needed it. So for relatively few numbers. And they have tried to expand Title X availability for women, even though that Title X program has been challenged. A second thing you see from litigation that you don't often see from the administrative process is you do get to cut through a lot of the administrative pages of difficult-to-read regulations, that prevent just one version of the facts and bias. And so when you have litigation, you have people in authority in the agencies who actually have to go under oath, and they have to account for their findings in court. And they have to, and this is another situation where when you have, to the extent that agencies are insulated from the political process, where they don't have political constituencies that they have to respond to, this can require them to pay attention to the religious interests. And under RFRA, they have to show, with respect to those particular religious views, that they they do have a compelling interest and that they're using the least restrictive means of meeting that interest. So one more thing that litigation can do, I think, is when you get bogged down into the bureaucratic process and a resolution takes a long time, regulators can see the writing on the wall, and you can get quick responses from regulators as a result of litigation. And we didn't see that very much in the HHS mandate cases. You got emergency injunctions from the Supreme Court, and the agencies didn't continue to press forward with the litigation. But I have seen it in other cases. So, for example, there's a case from the Trinity Lutheran case from 2017 said you can't exclude religious groups from government programs just because they're religious. So later that fall was just a horrible hurricane season. You had Hurricane Harvey in Houston, Hurricane Irma in Florida, and Hurricane Maria, and causing really devastating situations for all these groups. And FEMA has a program where you can, if you're a nonprofit, you can apply for help rebuilding in an emergency situation like that. But it excluded houses of worship from its program. So we realized that this was going to be a problem for houses of worship trying to rebuild. We brought a lawsuit in the Houston courthouse the morning that it opened after the floods, and we pursued the Trinity Lutheran argument on behalf of houses of worship. By the end of the first week of the litigation, the president had tweeted, "Of course, houses of worship should be able to get funding from FEMA," but the agencies kept litigating, and they didn't change their policies until 3 months later when we asked the Supreme Court for emergency review, because the houses of worship were still sitting there not being rebuilt, and they were missing deadlines. They were missing FEMA deadlines to apply for the funds. So the Supreme Court asked them to respond to our motion, and they changed the rule in time for the deadline. So those are some ways that you can see litigation working in these political processes. And you can see, hopefully the litigation provides a warning for administrators in the future that you don't run into these problems, but I think it can be a tool when you do have these, when you do have these intractable problems.
Thank you, Diana. Helen, since you went first, I'm going to give you a chance to respond to what the other two ladies said.
Okay. Thank you to both of you. Diana, I admire and envy your expertise, and this is all news to me about what went on into the litigation. I'm on the board of a group of Catholic Benefits Association, which provides health insurance that's compliant with Catholic ethical directives. And I know about some of the litigation to settle cases and to get fees paid, but I really didn't know about the interaction with the agency, so thank you very much. A couple of points in response to Renee's. So, who extended sort of the thinking, and I think appropriately so, beyond like a contraceptive mandate to the question of religious healthcare institutions generally and agencies trying to make health policy, and some people who are providing health care happen to be religious. What do we do about that? Well, there are some nuances here. A first thing to say is when it came to contraception, it's fascinating. So it's been, what? It's 2019. The reg that we're really dealing with still really came out in the form that mostly we know it, February 2012. And the U.S. Preventive Services Task Force has never put contraception on preventive health services. So like all the other stuff out of that Institute of Medicine report on preventive health care was deemed medically supported as preventive health care. But interestingly enough, even in the course of time from 2012 to the present, we knew the National Cancer Institute, we knew the World Health Organization and others, even as much as they said, well, some forms of synthetic hormones might have some beneficial effects. They also have stuff that kind of countermands that and says, but other forms have harmful effects related to cancer or blood clots. In the period between when the reg first came out and now, we know some of contraception's effects in connection with depression. One of the largest studies in the world on the relationship between synthetic hormones and depression. Again, it's not, the majority of women, but it's there. So the idea that they could recommend it generally as a preventive healthcare services, it just hasn't happened. So that's really interesting that, in a way, the idea that this should be standard healthcare versus something that individual women wish to make part of a life plan and a doctor or a nurse evaluates vis-a-vis their particular health situation. So the idea that the baseline is that this is general preventive health care, I think, is not actually medically so. And it's still fascinating how controversial some of the side effects are. The other thing with regard to abortion, one of the interesting parts of the debate, and I think it was, I can't remember whether at this point it was Hobby Lobby or Zubik, where the Supreme Court says, if you make the baseline of what is due to people, what's fair, is anything the government announces as a mandatory benefit through private suppliers, and I know that's our healthcare system now, right? That's how it's done. And then anyone who doesn't do that is violating some need for a system that's integrated in general, kind of like the Lee case about the Amish paying taxes, that, if we let them not pay taxes, then everybody's going to want to not pay payroll taxes, Social Security taxes. And the government tried to make this argument, say, no, we have to have a universal system where everybody provides this benefit, because if you don't provide this benefit, then you're taking something away from third parties, like you are taking away Social Security benefits from non-Amish employees or employees of an Amish firm. And the Supreme Court said, well, do you mean that, if the government chooses to make abortion a generalized mandatory benefit, then not providing it is going to be de facto a problem, because you're going to allow an exemption for religious organizations and they're going to be hurting third parties, and so that you're not allowed to make this? And you could see the Supreme Court was really afraid of that argument, that anything the government announces as a mandatory benefit, even through private employers, becomes the baseline. So there's that problem with abortion. The other problem is abortion as health care. And this will be my last, I'll have one little point after this, but I was asked to testify on conscience protection for abortion across federal law. This is under the Obama administration. I was testifying in front of a Democratic House committee. And what I did is I went through every single most recent health information and guidelines that the Obama administration had issued regarding women. So I looked at the White House Office of Women and Girls. I looked at everything HHS had. I looked at everything NIH had. I looked at everything the CDC had as advice to women regarding their health care. And it turned out the advice was always about how to be healthy in order to have a healthy unborn child. This was the language that the federal documents used. Abortion was never, not once, not ever, in federal documents, referred to as health care. And you don't see it referred to that way in generalized medical literature, the books used in med schools, et cetera. So the idea that abortion and contraception would be some kind of special problems for which you would have to treat religious providers separately, actually they're not sort of universal baselines in the first place from which a religious provider is deviating. With regard to my description of CSE and SRA programs, Renee's right, I'm far more complete in my text, and I did say that even the CSE do recommend abstinence before they go on to talk about usually providing contraception. And I think that's all I'm going to comment on. Open for questions.
Okay, great. Diana, Professor Landers, do either of you have anything you'd like to add based on what everyone else has said?
No, I just wanted to say two things on the Title X point. Now we have a situation where the government is, has announced this proposed rule to that will have the effect of excluding Planned Parenthood clinics from receiving Title X funds. And I think that there is a great deal of warranted concern that this will actually diminish the availability of healthcare in many parts of the country, because Planned Parenthood clinics are the operators, Planned Parenthood organizations are the operators of these clinics that are funded with the Title X funds, and obviously they're not used to fund for abortions, but they do provide a variety of other healthcare services. I also wanted to put the sort of science issue into a little bit of a larger context. This issue's come up about the legitimacy of science and who participates in the process in a number of different agencies. So, for example, recently it came to light that the Environmental Protection Agency's Science Advisory Panel now excludes scientists who are employees of the EPA, but includes scientists who are employees of the regulated industries. Now, it seems to me that maybe both of them could have a seat at the table. And then I actually, and I know nothing about aviation, but this whole business over the 737 MAX 8, it just sort of seemed, this is the one time where I thought President Trump got his tweets correct, that common sense indicated that maybe you would ground that plane before you put hundreds of other people on that plane, before you knew what went on with these crashes. And now all kinds of information is coming out about some regulatory failures. And I think there's, enough blame to paint, both parties with, some responsibility for this. And so, the science can be co-opted, and that is not a good thing. But I think that's why, we have people like us and people like journalists who really try to call the agencies out, and litigators, when that kind of bias is infecting the quality of the decisions. And so, sometimes it takes too long and people are hurt before we get to that point. But I think that it's something that we have to, be vigilant about.
Thank you. Go ahead.
Can I just add, on that point, it is helpful that the agencies do have faith-based offices where they're supposed to be listening to minority views, and there's also the common processes for people to contribute. But I do think that litigation does force the agencies to really bring their arguments to the table about specific religious views.
Mm-hmm.
So, Helen, in your paper, you provided a number of recommendations as to how we might work towards solving some of the polarization that we see in the issue generally, and the science regarding the issue, and how that can be politicized. So now, do you think that, I love that you have recommendations, because we do need a path forward, but how idealistic are those, or overly optimistic might they be?
Right. Sometimes I remind myself, Robert Putnam, he's a sociologist, is he at Harvard, who wrote the book, Our Kids? Yeah. And he's doing this interview with the Washington Post, and you can see, because they put the ... dots in the interview, where he goes, well, it's about the well-being of kids, so I'm figuring people will get on board, maybe. Like my husband always says to me, Helen, kids don't vote, they don't give to campaigns, what are you doing? You're not going to get them on the agenda. So I know that I tend to be idealistic on this. I intend to press forward on the idea that people would love it. And every once in a while, there are political figures or corporate figures or media figures who do such a thing, and I see the praise they get for being even-handed, acknowledging the material on both sides. Whether we're talking about, evidence of climate change, and, I think you're saying, it's too drastic, or I think it comes from this but not that. Let's have at the details. So I wish in my arena, which deals with the family, to constantly, relentlessly, and maybe eventually with some efficacy, to call for saying, well, this program has this behind it, but it's lacking this. But on the other hand, we have government programs that have been around for a long time, which are essentially a good idea. They haven't done enough yet, but we intend to keep trying, because this is a fundamentally logical idea, and we can't leave these kids behind, or we can't leave this public health crisis untouched, and we're going to keep trying. I am always I'm trying to make a market for this kind of conversation by continuing at it.
So I think that's a really good point. And I think that one of the things that's troubling about our culture is that we talk a good line when it comes to kids, but we really don't deliver. And, if you look at the status of public education in the country, the college admissions scandal only kind of highlighted, what some of the issues are with the educational system. And we really need to think about a way forward as a country where we can invest in the future, and that means invest in the kids, as well as climate change, other things that we might think that we need to do, because that we're losing whole generations of children because we don't have the underinvestment.
So, and this is a very difficult question, so if you can bear with me, but how do we go about incentivizing better medical advice, especially given that there's not necessarily a compelling interest on the part of agencies to provide that, given that courts provide a lot of deference to what the agencies say. So you can see where incentives might not be aligned. So is there a way to incentivize them, or a way to make structural rule changes that would have the positive effects, or do we leave it to litigation?
Did you want to?
No, go ahead.
Okay, it's one thing if you have a working relationship with leaders in agencies to incentivize this kind of thing, but they're inside of an apparatus that I tend to agree with Renee on this, has been quite responsive to the politics on sex and reproduction in the last couple of administrations. But for me, I will tell you that I chose to go about it through an outside, I literally founded a nonprofit in relationship to the contraceptive mandate to speak up for, to write on the topic. And by my nadir, I had 77,000 women on a list, up to 300,000 some weeks of women checking the site, to provide them with good information in order for them to pressure their representatives I filed amicus briefs on their part, wrote law reviews, they gave presentations, wrote letters to the editor, et cetera. I have to say, I did it, again, I was trying to make a market for it. That's the way I did it. I didn't do it in a precisely a lobbying fashion. Some of them did. I sent them out lobbying. But unless there is a taste in politics for a yes, but conversation at what's at stake, then I just wanted to create that taste by having people be loud in their local arenas. And it was a huge, extremely exhausting and granular effort. So it's really hard. I'd love to hear better ideas.
Well, the other problem here is that the scientific evidence is a moving target, right? So, what seems true or clear today may not be so true and clear tomorrow. However, you have to go with the best information you have. And so I just think that, we can place some reliance on professional organizations, and, Helen would probably disagree with this, but, like the American Academy of Pediatrics or obstetricians and gynecologists, because they have no interest in doing harm to their patients. That's really not part of their, get up in the morning and think about how can I be sued for malpractice tomorrow. So I do think that we can have some confidence in them trying to sift through the information and coming up with, yes, contraceptives can be good for some, but not for others because of these risks. And there's hardly any medical treatment that doesn't have some risks, not just in this area.
Well, I'm going to ask one quick question before I turn it over to all of you to ask your questions. So given that this process and this issue with reproductive health and sex and contraception, and it's so represented by, it's so influenced by the political process as we've seen in the last few years. So what happens when we have minority religious beliefs or minority religions who don't have much influence or say in the political process at all? Diana, do you have some comments on that?
Sure. Well, sure. Well, as a litigator, when you have a hammer, everything looks like a nail. I do think that the litigation can bring out the views of minorities in the administrative process. And one example of that is the Singh v. Carter case that you mentioned earlier. We represented this actually is a long administrative story, but in the 80s, the Reagan administration changed the regulations in the military to be much stricter for headgear. And so no religious headgear was allowed. There was actually a legislative fix for religious headgear, and the agencies interpreted that to only include yarmulkes for Jewish servicemen. So Sikh soldiers of the Sikh faith required a turban and a beard, and the regulations weren't interpreted to include those. So we represented a Sikh serviceman, Captain Singh, and he actually was in the Army for 10 years before he realized that he had a chance to carry out his faith in serving. And the agency, we brought a lawsuit, and the Department of Defense was like, oh, well, we'll look into this. We'll do a lot of testing and see if we can figure out how to do it safely. And by the way, show up at Aberdeen Proving Ground, and we're gonna test you. So we got a temporary restraining order against that, and that really forced them to change their regulations on the timeline that the litigation required, and not their bureaucratic slow timeline.
I have a wacky example on this. So I have a former student who works for correctional legal services in Massachusetts, and there was a client. She, was assigned a client who was incarcerated, and the Department of Corrections went into court to require him to take his antipsychotic medications. And he said that I don't want to take them because I am a Satanist, and it is against, we believe in physical autonomy, and I don't want to, in my religion as a Satanist, I cannot be compelled to take these medications. So she took them seriously, and she had the person who was in charge of his religious group, I don't know what they call themselves, in Salem, Massachusetts, testify in the court proceeding, and she got a decision from the district judge saying that the Department of Corrections, that he could not compel him to take his medications because of his sincere religious satanic beliefs. So it can go in a whole bunch of different directions.
Okay, that's definitely an interesting example. I'd love to open it up to all of you to see if you have any questions.
Yeah, so thanks to all the panelists for your interesting remarks. We discussed the partisanship and agency action, and I'm interested in not only partisanship in studies, but the role of money in studies, and I'm sort of surprised that the role of the pharmaceutical industry hasn't come up. In my own experience with HHS in trying to increase interest in and attention to more natural forms of family planning, which are less expensive and healthy and are not drug and device dependent, was that there are so few studies done. The only studies that were done in the efficacy of those methods were third world studies that were deemed inapplicable to the West. And a lot of this is what type of funding even the studies are getting. So In the private sector, you have industry, that is pharmaceutical industry-driven studies, and in the public sector, it tends toward this politicization. So can anyone comment on that? Do you have a problem with funding the studies?
Well, there are some new ones because there are these new apps that promote natural family planning methods, and there have been some studies of those. And so I think that it's kind of changing. And I think that the funding can be a mixed bag, because I think you're right that the pharmaceutical industries has an interest in promoting, products and devices, because that's what they sell. But and that can have a distorting influence on the FDA because of the way the fees from the pharmaceutical industry fund the FDA's approval processes. But I do think that that some of these studies have started to happen. I mean, I actually happen to have with me today a couple of articles talking about them. So I would say you're right. It's distorted, but it's not. There are studies out there, and they have been done in the West, in Europe, and and somewhat in the United States. I wanted to say something about your earlier question for the last panel about the rigged comment process, because it's really sort of at the core of the administrative law a little bit. So it's this natural thing that people try to, an agency puts out a proposed rule. They obviously think it's the right rule. They try to get people to come and testify, who they think might agree with them. And then there are the interest groups who will line up against it or in favor of it as well, who independently find out about it because they follow these things. But the internet has, had other distorting influences on the rulemaking process. So the FCC's regulation, when it withdrew the regulation on privacy at the beginning of the Trump administration, they got many hundreds of thousands of comments, many of which turned out to be, like robots and fakes. And this is the FCC, right, who should, in theory, be kind of on top of this sort of thing. So, so that's why courts don't sort of count up how many comments on this side and how many comments on that side when they evaluate whether an agency is acted with appropriately in a rulemaking proceeding, because of that problem of who comes to testify and to make comments. But I encourage people to make comments. So my next assignment in my administrative law class is, I'm torturing our librarians to come up with rules that my students can write comment letters about. So trying to get them in the habit.
I think we have another question up here.
Well, this is sort of a narrow doctrinal question, I guess, but I think it opens up into maybe some broader themes, and it's especially relevant, I think, in the HHS contraceptive mandate context. And that is, we talked, starting, I think, with Mark Mosesian this morning about the compelling interest test or the RFRA standard. But of course, the second prong of that is this narrow tailoring or least restrictive means inquiry. And it strikes me that it points up sort of larger shortcomings in how we kind of think about the application of strict scrutiny in a lot of other areas. But it strikes me when an agency is trying to figure out, say in this context, what is the least restrictive means as it's required to do under RFRA, where do you set the baseline? And again, it's not particular to this context. I mean, Justice O'Connor talks about it in Grutter, I think in ways that are not entirely pellucid either. So I just think that across the board, it's an area where it seems to me administrative law and these kinds of issues, I think, are sort of in the dark.
Just a brief comment. I thought that was one of Mark Renzi's best comments, is the number of tools at the disposal, the amount of discretion to carry out a mandate of some sort, a legislative direction. It leaves a court able to put a lot in their lap, and they have certainly put a burden on the agencies, my goodness, after Hobby Lobby and with Zubik, to affirmatively come forward with things, including to the point of paying to provide, what the government has mandated the private companies or insurance to provide. I don't see any rules batting around in the cases on least restrictive means, a way to formulate it. It's a litigator's paradise to decide what that means. There's one other, the other thing just about baselines on this, about how you would provide that by least restrictive means. I think in these areas of anything that you can analogize to abortion or eventually euthanasia, the last thing they're going to want the government to be allowed to do is make the baseline providing this thing. If you can, we have had, just like you've had a history of chaplaincies, and that historical element has been a big factor in allowing, and I know that's in a non-establishment claim, but on the historicity of exemptions, abortion goes way back there. It's even in language in Roe versus Wade. The court says, oh, of course there's going to be conscience exemptions, and we all understand that this is well and good, and as it should be. So the idea that the government could ever put it on the private sector, including religious institutions, that a baseline is providing these things. It seems to be different for the case of the vendors in marriage, but when it comes to sex and reproductive health, this stuff has been so neuralgic for so long, and there is such a history of exemptions from the 1970s forward that I think they're going to have a much harder time saying that providing it is the baseline. And as for least restrictive means, it's a goat rodeo as far as I'm concerned. And it's a matter of litigation clever.
Well, I think that the lawsuits against Harvard on the undergraduate admissions process, I don't think that district court decision, which we don't have yet, will be the end of the story on that one, will perhaps enlighten that a little bit, because that's really basically, now there's been this microscopic examination of at least one college's undergraduate admissions process. And so the question is, has it been faithful to this dictate of trying to find narrow means of, implementing this goal of trying to increase the diversity in the undergraduate student population?
We have time for a very quick question, if anyone has one. Okay, well,
There's one.
Yep, great.
So with my limited familiarity with the contraceptive litigation cases, my understanding is that they generally focus on the burden on the parties, and they kind of either ignore or take for granted that it's a compelling government interest. And is that a correct conception? And if so, can you address that? Or maybe just not quick enough. So, thank you.
Sure. Well, in the Hobby Lobby decision, the Supreme Court assumed that there was a compelling interest, but it didn't reach that question. But we have made arguments that if you exempt 1/3 of Americans from having a plan, like 1/3 of Americans have a plan that is not required to include contraceptives because of grandfathering exemptions, and because if you are an employer that has fewer than 50 employees, you don't have to provide insurance at all. So if you offer exemptions in other contexts to say, oh, we can't offer this exemption in a religious context, it's hard to argue a compelling interest, and we have made that argument in courts across the country.
But of course, the contraceptive mandate was not the only issue in the grandfathering decision about those existing plans.
Okay, well, on that, I want to thank you all. I've really enjoyed this, and I hope the audience has enjoyed it as well as me. And thank you all.
Thank you.